for the first time we have speakers here, I would like to emphasize that our two guests represent two parties in a way to symbolize two parties to engage in the conflict, and they are separated just by chance. That's hazardous that I sit in between. That was not deliberate. We start with the first two presentations concerning the legal basis of relations between Ukraine and the Russian Federation, or the Russian Federation and Ukraine. And our first speakers are Maria Issaeva from Threefold Law Office in Moscow, and Professor Oleksandr Zadhorozhniy from the Institute of International Relations of the Taras Shevchenko University in Kiev. Then three other speakers who will be engaged in the issues of self-determination as crucial for this issue are Theodor Christakis from the University of Grenoble, Christopher Borgen from St. John's University in New York, and Władysław from Novosibirsk State University. I suppose we'll have a short coffee break before the three presentations. So we start immediately, and I would suggest we start with Maria.
Thank you very much. Can you hear me well? And as we are all here to mark by this academic legal discussion a one-year anniversary of the annexation of the Crimea by Russia, I wanted to thank the organizers and personally Władysław for inviting me and for giving me a chance to be the first speaker of this conference. Briefly, I'm a partner at a law firm in Moscow. We focus on issues of public international law, human rights, and protection of business interests at the European Court of Human Rights. And of course, due to our profile, we were observing the developments around the Crimea and the situation between Russia and Ukraine in the past year with a lot of attention and grave concerns. The speech, however, reflects my personal views. And given the sensitivity of the situation, I just want to make it clear. And they do not reflect the views of our company. My speech will be structured as follows. In addressing my position on the matter, I will concentrate on certain crucial key facts, which I think are very important for us to keep in mind as we are discussing what has happened. Because in my observation, certain facts sometimes we tend to miss them, maybe misinterpret them. Let's try to stick to the facts because it will add to the quality of our legal discussion. And I will also address a number of positions taken by Russia, by the Ministry of Foreign Affairs of Russia in the past year, to which I will refer as MID, just to speed up the proceedings, and partly academic views taken on the matter, which we have seen in the past year in Russia. So the legal qualification of the case with regard to the Crimea, in my opinion, is very, very clear-cut. In light of all the information available in public sources by now, and it's very straightforward from the point of treaty and customary international law. And I think that most of the international lawyers worldwide by now have agreed on this qualification. So in order to qualify the situation, we need to answer three very simple questions. Was there a use of force by Russia? Was this use of force lawful? And why is this relevant? What does it have to do with the question of self-determination? So I will, in my speech now, give my position as to the answer to those three questions. The relevant treaties to which Russia is a party, relevant treaties with Ukraine, are several bilateral treaties regarding the Budapest Memorandum, which was already mentioned, 1994, on security assurances in connection with Ukraine's accession to the Treaty of Non-Proliferation of Nuclear Weapons, Treaty of Friendship, Cooperation and Partnership between the Ukraine and Russia, and Black Sea Fleet Agreements, of which there are four, three agreements of 1997 and one of 2010 extending, and adding certain conditions to the first three. Obviously, Multilateral United Nations Charter. All of them speak on territorial integrity obligations of Russia with respect to the respect to the territorial integrity of Ukraine. In addressing those obligations of Russia, we must not forget, of course, about customary international law and the documents in which the positions of the majority of states were reflected, and the well-known Declaration on Principles of International and Friendly Relations by the General Assembly, the Helsinki Act, and the definition of aggression. So briefly, those are the sources. So what's the use of force by Russia? In the first days after the Crimean crisis hit, given the information available at that time, the allegation of use of force against Ukraine by Russian military forces was somewhat balanced against the claim by Russian highest officials that all the actions there were those of separatists, which could raise some questions of attribution. The first admission to the contrary was made by Russia on 17th of April 2014. By now, we have multiple statements by Russia's highest officials with regard to Russian soldiers' participation in all the Crimean events. I can quote the statement of President of Russia of very, very recently, where he said that they needed specialists that knew how it should be done. For this reason, I quote, "I gave instructions to the Ministry of Defense." Well, I won't hide it under the pretext of increase of security of our military objects in the Crimea, to send the special forces of the main investigation service of Russia and the Marine. Of course. That was actually spoken in June last year in an interview to the French television. Also, the Vice Prime Minister of the Crimea, Timur Galiyev, in March said that in March last year said that all military forces of Ukraine, all their forces that were in the Crimea are blocked, partly disarmed, and part of them is transferring to our side at the moment. And it was already noted, it has been noted by many commentators over the past year that these actions clearly fall under the definition of aggression, and namely it's paragraphs A, C, E of Article 3. Minister of Foreign Affairs, MID of Russia, says that no single shot was fired in the Crimea in order to justify lawfulness of the use of force. However, according to international law, the standard of an armed attack is a threat of force of potentially lethal force. The definition of aggression does not include the requirement of lethal consequences in the territory under attack. And the consequences of this armed attack are always quite grim. In the event of Ukraine, even leaving all the possible multiple considerations apart, the situation with taking one of the many Ukrainian Russian-speaking regions could not but provoke, and it could be expected, it could provoke separatist aspirations in other Russian-speaking regions in the East Ukraine. And as we know, that's exactly what has happened in the past year. Again, leaving all the matters that can be discussed with respect to the Eastern Ukraine apart from that. Furthermore, and that will conclude my address of the facts in this respect, in a very recent documentary, the Crimea, The Road Home, which has just been released on Russian television to mark the anniversary of the Crimea, as Russia put it, reunification. The Russian president said, well, basically he spoke out a threat of nuclear weapons coming from Russia with respect to the Crimea. What he said was that they were ready to do it if something went wrong. Such threats are by definition contrary to international law, and as we know, save for the remark made by the ICJ in the advisory opinion of 1996, save for extreme circumstances of self-defense in which the very survival of a state would be at stake, which was obviously not the case with Russia and Ukraine a year ago. Well, the MID tried in the 1st April last year, they said that the negative guarantees under the Budapest Memorandum we comply with them, and there is no intention to use nuclear weapons or to threaten to use it against non-nuclear powers such as Ukraine. So one year ago we had this statement, now we obviously have something totally different. Proceeding to the second question, was the use of force by Russia lawful? Here my answer will be no. And there will be a separate panel on this. However, as it is, in my opinion, very relevant to self-determination, and I'm going to speak on it later, I will quickly address why. The presence of Russian military and its actions were in violation of the 1997 agreements with Ukraine. Yes, Russia did have the right to have military forces based in the Crimea in the numbers which maybe were not exceeded by the time Russian forces entered the Crimea and Ukraine last year. However, the obligation was to state the specific places of dislocation and not to violate Ukrainian sovereignty. Those are spoken directly in the agreements. There was no United Nations Security Council authorization for the use of force. Very importantly, it is the first case in the post-World War II order where a permanent member of the Security Council did not even address the Security Council before resorting to use of force. No situation of self-defense. The concept of remedial succession, which is highly disputed, as many things are in academia, international law academia, it addresses preceding situation of massive human rights violations, even if we stand on the point that it exists on an unlimited basis. Despite the numerous claims to the contrary, there were no massive human rights violations. As follows from the publicly available sources, we are dealing with the approach by Russia which pictures an unsuccessful attempt by the new Ukrainian government to cancel a package of laws on the use of Russian as regional language as a massive human rights violation, and the failure of Kiev of such a scale that gives rise to the claim to separate the territory from the parent country together with its population. This is clearly disproportionate. It's a misinterpretation of the remedial succession concept. This norm does not exist in international law. Use of force by invitation. It is one of the possible arguments. In my assessment, it is a weak one. The claim essentially is that the legitimate president, the democratically elected president, was still around. He fled the country, but he could give instructions. There are considerations, I don't know if we are going to discuss them later, maybe today, about the effectiveness of the fleeing president, whether he still was exercising power over the country. However, on the facts, I wanted to add something here that 2 weeks after the referendum on the Crimea, Yanukovych actually spoke against annexation of the Crimea by Russia, and he stood for the Ukrainian sovereignty in an interview. In these conditions, the argument that he could invite Russian forces specifically to occupy the Crimea hardly holds water. Other arguments were adduced by Russian legal commentators in support of lawfulness of the use of force. I will not address them in detail now. We are going to have a separate panel on this, but I'll briefly mention them. That basically the use of force, to justify the use of force by Russia, we use the argument as illegitimate government in Kiev, often combined with popular rhetoric of fascist junta. Second is response to the intervention into domestic affairs of Ukraine by the United States and the European Union, which entailed the Maidan. Another possible explanation is, again, lack of blood as a result of the use of force of Crimea, and I addressed it briefly. Also, we have return of Russia's historical territories, which I believe falls into the irredentism concept. Those arguments do not stand up to any criticism. Again, I will not be speaking on it in detail now, but I'll be happy to have an extensive argument on that separately, so I'll be happy to share it with you if needed later today. Then let's move to the third question. Why is the issue of use of force relevant at all, and what does it have to do with the question of self-determination? well, it is highly relevant as such as an international wrongful act and a violation of jus cogens, first of all. And we are going to speak on that. Furthermore, the use of force is not actually part of the well-known dilemma between self-determination vis-à-vis territorial integrity. International law, general international law is quite clear on the matter. I will now concentrate on the main arguments why the unlawful use of force by Russia effectively negates the validity of the referendum on self-determination. One of those arguments, in my opinion, is that some of the statements of Russia's officials that we have by now point towards using self-determination as a pretext to acquire territory. The idea of principle of self-determination is to give people their rights and not to place the neighboring country on their territory to protect its national interests. By the moment, we have a number of statements which basically say, unless we did it, it would already be in the hands of NATO. And we have academic statements to this effect as well. So on the 18th of March 2014, Putin said, I will remind that Kyiv has already spoken joining NATO as soon as possible. For the Crimea and Sevastopol, it would mean the NATO fleet would arrive in the city of Russian military glory. On 5th June 2014, Russia's president stated that they could not act otherwise in a situation where a historical Russian territory with the mostly Russian ethnic population would join some international military alliance. While the president keeps adding that people of the Crimea wanted to join Russia, this argument is often corroborated by the rhetoric according to which people in the Crimea were Russians in any event, and they would obviously vote for joining Russia, even if the Russian military were not there. They were only there to secure their right to vote properly as they wanted to. In response to that, I would like to cite to a famous tribunal, with your permission. And this tribunal put in one of the landmark cases for the modern international law. I'm going to omit the names of the actors for a few seconds, and I quote now. It was contended before the tribunal that the annexation of a certain territory was justified by the strong desire expressed in many quarters of the relevant region, that there were many matters in common between the two peoples that made this desirable, and that in the result the object was achieved without bloodshed. The tribunal immediately continued to conclude, these matters, even if true, are really immaterial, for the facts plainly prove that the methods employed to achieve the object were those of an aggressor. The ultimate factor was the armed might of the relevant country, ready to be used if any resistance was encountered. Moreover, none of these considerations appear from a certain combination of statements, in that case and in our case, to have been the motives which actuated the head of state. Yeah. On the contrary, all the emphasis is there laid on the advantage to be gained by Germany in her military strength by the annexation of Austria, and the quote belongs to the Nuremberg judgment. Intervention and use of force by Russia and lack of independence of the Crimean government is the last very important aspect that I wanted to touch. Self-determination cannot be exercised as a result of the illegal use of force. There is indeed abundant state practice to the effect that a declaration of independence under foreign military occupation renders such declaration unlawful in light of international law, and an entity declaring its independence in such circumstances is not regarded independent. And the United Nations Security Council consistently declined the lawfulness of such declarations of independence, and it was noted by the ICJ in its advisory opinion on Kosovo. According to the most recent statement of President Putin in the documentary which I mentioned, it was him who gave the order to start a special operation to return the Crimea on 22nd, 23rd of February. The government of the Crimea, well, it's his direct speech. I can see that someone is disagreeing with my words, but I'm quoting to him. The government of the Crimea had no issue of external self-determination on the agenda until the then unidentified armed groups entered governmental buildings on the 27th of February. The issue of self-determination appeared on the agenda for the first time then. And that happened on the day when the former deputy, one of the former deputies of the Crimean parliament, Sergei Aksyonov, was elected as the Prime Minister of the Crimea, and the self-determination referendum was actually announced. There are multiple statements of media concerning in the pro-Russian mass media, like Interfax, for example, which say that we cannot establish what was happening in the parliamentary building on that day because everything, like basically there were armed groups, telephones were cut, no members of Secretariat were present. So the issue of quorum on that day at the parliament is a huge question of facts. Again, another quote of one of the eventual leaders of the Donetsk People's Republic, Igor Strelkov, who was also present in the Crimea. And he was involved in taking over governmental buildings. He stated on television that we were forcing deputies to go into the building and vote. The date of the referendum was announced and scheduled and then moved 3 times. It was initially planned for 25th of May last year, and the discussion had to be the expansion of autonomy of the Crimea. Then, on the 1st of March, the date was moved to 30th of March, and then on the 6th of March, they decided to move it to the 16th of March, and they reformulated the questions to address the issues of well, actually, there were only 2 issues. The people were not offered an opportunity to vote on the status quo, to stay within the Ukraine. 2 questions were presented. One, whether they want to go back to the extended powers of the Crimea by the 1992 Constitution, I believe, and Oleksandr will correct me if I'm not quoting it properly. And the second was to actually join Russia. Before that, the Declaration of Independence was announced before the referendum on the 6th of March. Exactly on the day, I think, when the date was scheduled. All these questions the independence of the government. Ironically, and the last thing I'm going to say, I noted one of the statements made by the Russian academia in the past years, one of the Russian academics. He's saying that there is a nuance, that the international law, speaking on the right of self-determination, gives this right only to a people and not to a population of a certain territory. And then listen, then here a smart solution was found by lawyers and administration of our president of Russia. Because 3 days before the referendum of the Crimea declared itself an independent state. And an independent state, it's already people and not population. Just listen to it. Independent state, our president decided. A smart move. It seems that actually many people understand what's going on there, and that the international arguments are presented as a simple wordplay at the moment in this regard. In conclusion, I just wanted to say that I hope in these 2 days we will have a fruitful and friendly academic discussion, and we will discuss all the issues and will achieve an opinion which I think is very important, that while politicians cannot agree on a situation, the situation from the standpoint of international law can be formulated, and we international lawyers can actually work on fixing a violation in our opinion and in our minds before the situation is actually solved. So I very much hope that in these 2 days we'll be able to do exactly that. Thank you very much.
Thank you very much, Maria, for this presentation. In fact, it was it dealt more with the application of international law than theoretical, or more or less theoretical basis of relations between the 2 states. But I suppose that there will be an opportunity to discuss the role of bilateral treaties between Russia and Ukraine in the context of what has happened, in the Crimea. Oleksandr Zadhorozhniy, University of Kiev, Ukrainian perspective.
First of all, let me express deep gratitude for the invitation. Of course, for me, it's an emotional matter. I was standing in Maidan for 3 months, trying to defend the right of the Ukrainian people to go by European routes. And what has happened at the end is a gift from our fundamental brother, Russia. They have annexed the Crimea. But the Polish people have supported us. And the Polish government and the Polish people were sending not a humanitarian, but a brotherly, really brotherly help. And a lot of wounded at Maidan were evacuated from Maidan because of the Polish aircraft, special aircrafts which were sent during these events. And we are really, I mean we, Ukrainians, those who were standing in Maidan, let me express gratitude, first of all, and for the invitation and for the possibility to talk here. Second thing, I would rather talk without any emotion, try at least, and try to analyze particular legal grounds of what has happened a year ago. I would rather draw your attention to 5 points in so-called self-determination, although after revelations of Mr. Putin during the last 3 days there is no necessity even to talk about it because everything was blatantly and explained to all the humanity that what has happened. But in any case, notwithstanding what was said during the last 3 days, I mean by the Russian officials explaining the events, the main concept which was used and still is used by the Russian official doctrine and the Russian doctrine of international law, that's the concept of a self-determination. That the Crimean people, whoever they are, they have determined to become a part of Russia. And the whole idea of the anniversary is the reunification of the people of Crimea with the motherland. Notwithstanding the fact that all possible legal norms were violated, notwithstanding the fact that everything was done by the brutal force, notwithstanding the fact that this is brutal force and the occasion was using the situation when it was really a chaos in Kiev. You do remember that on the 21st, exactly on the 21st of February, there were first mass killings of people in Kiev, and for 2 or 3 days the country was not only in shock by this situation, but we really didn't know what to do. The president, or so-called president, has fled. We have nominated an acting president, and nobody was knowing what to do. But in any case, 5 points of the situation. First, who or what? There is a subject entitled for the self-determination. The second question, grounds for self-determination by means of secession. The third point, availability of any other means of self-determination. The fourth point, involvement of other state in the process of self-determination. And the fifth one, that's the recognition of similar instances of self-determination of peoples by means of secession. I will not exceed the given time, and will try at least to do this, and will try in 10 minutes which left to me to analyze briefly 5 positions. First, the people entitled for self-determination. I would rather cite the Russian position. If Russian side is avoiding direct statement as to which people is deemed when talking about self-determination of Crimean people. It is obvious, if we will speak about Russian, so that means the minority, yes, and the minority is denied the right of self-determination according to all existing international law norms. If we are talking about Crimean people exercising its right of self-determination, means the population of Crimea as a whole. That is how people of Crimea and population of Crimea may be interpreted. That means that every subject of Russian Federation, administrative territory, administrative region, republic, is populated by a separate people entitled to succeed. However, the Constitution of Russian Federation of 1993 prohibits succeeding, and this provision was subsequently upheld by the Constitutional Court of Russian Federation in its decision of 7 June 2000, number 10p. Why should the opposite apply with respect to Ukraine? Second point, exhaustion of possibilities of internal self-determination. I would rather draw your attention that Crimea, for the whole history of Ukraine, or for 23 years, has been a very specific region with, let's say, different rights and with a specific autonomy. Russian publicist Yavkin, and I'm citing his work, «Проблема обеспечения единства и территориальной целостности государства в условиях борьбы народов за самоопределение». This PhD thesis were in 2004 in Moscow. Is stressing. It becomes more widely recognized that form, from the practical point, internal self-determination should be chosen over external one. Democratic institutes and mechanisms of group representation, federalization, autonomy are to be built, allowing all members of the society to participate effectively in governing and distributing resources while maintaining territorial integrity. Thus, although the Crimea was granted a broad autonomy within Ukraine, and it is totally compatible with the international legal concept of internal self-determination, at the same time, provision is no way exclude the possibility to hold discussion on the alterations to such status, particularly on the broadening of Crimean authority, autonomy, competence, and there are also no grounds to claim that such possibilities have been exhausted. Notably, even expressing its position on Crimea, Russian recognizes in their practice states have reached a consensus that self-determination of peoples shall take place as a rule within the existing states, in particular by means of autonomy. That's the explanation of an official document of Ministry of Foreign Affairs of Russia, published 27 October 2014, page 1. Third position, legality of secession as means of exercising the right of self-determination. I would not dwell a lot on that point. I would like to draw your attention that a lot of points was written from the Ukrainian side, and so the one thing. However, support of the majority of nationals living in Crimea and having participated in 2010 in presidential elections for Yanukovych shall not be reckoned as evidence of exclusion of Crimean population from the national communication. I mean those arguments which were published by Dr. Tolstych and the others here, that somehow, because of situation in Maidan, somehow Crimean people were excluded from Ukrainian national dialogue. No member of any parliament, no member of the Parliament of Ukraine, elected by majority vote system in 2012, a representative of a party voted for in the Crimea, the Party of Regions, and the Communist Party, was excluded from the parliament. And this parliament further represented the people of Ukraine, including its Crimean part. Pursuant to Article 75 of the Constitution of Ukraine, Verkhovna Rada is the only organ of legislative power representing the peoples as a whole. And the last one, neither institution of criminal proceeding against certain members of political party, no fights in Verkhovna Rada and deputies leaving defections may be interpreted as excluding from national communication or population of a region. It makes no difference that the government was constituted by the representatives of only two parliamentary parties, given that was the people of Verkhovna Rada Ukraine voted for. Those deputies may have been the representatives of virtually any party in at all. The fourth position, involvement of another state in the secession to exercise the right to self-determination. There is no need to talk here about it. I would rather draw your attention to only one fact. President Putin, on the 26th February 2015, signed a decree on the Special Operations Forces Day to be celebrated in honor of this unit of Russia's armed forces. The official publication in Russkaya Gazeta had an article devoted to this event stating, why would 27 February be chosen to celebrate the Special Operation Forces Day, despite these forces have been formed on any other day? Remember where and what was happening a year ago and what it ended with. Of course, the participation or even involvement of Russia in the events in Crimea is obvious. A lot of documents and a lot of official statements were published, again stressing it during the last 3 or 4 days. And the fifth thing, that the case's recognition of self-determination of people by means of secession by international community. Again, there is no any necessity to speak broadly on this matter. I think that almost all publicists have analyzed these events. Weller, Widmar, Walter, Joritsma, Krish, McCorkdale, Maxu, Marksun, Pelle, Peters, Fox, 50 names, are stressing that all possible norms were violated, and there is no way and even chance to analyze the official position of any international organizations which were stressed here by our distinguished introducer and the representative of Ministry of Foreign Affairs. Consequently, in accordance with international law, actions of the Russian Federation with respect to Crimea may be interpreted only as a military aggression, unlawful military occupation, and annexation, namely forceful annexation of a territory, a part of a territory of another state. That's it. Thank you.
Okay. Thank you very much, Oleksandr. In that way, we have stepped directly into the hot topic of this conference. And before I give the floor to the audience for questions and comments, I would like to abuse my position as chairperson in this panel and ask our Russian and Ukrainian colleagues to comment briefly on 3 points. First, what is your evaluation of the Budapest memorandum? Second, are there any bilateral treaties between Ukraine and Russia concerning basis of relations, because that's important for the evaluation of the situation? And third, a brief comment on an agreement on stationing of Russian forces in the Crimea, because I think that at least a part of the audience is not familiar with those treaties, and it might be interesting for the future discussion just to give some details of those agreements. So I reserve some minutes for the comment, and now I open discussion. Yes, please. Please introduce yourself. Okay. Before speaking.
Jacek Potocki, I'm an international lawyer as well as international columnist. My question is, to what extent the case of Crimea is different and to what extent is similar to the case of Kosovo?
Thank you. I would like, first of all, not comment. Maybe I want to ask our colleagues from Ukraine and from Russia. It's very interesting opinion we see here. If you really believe or think that the principle or right to self-determination is still exists in international law, is if do you believe or do you support? I want to know in what form do you want it exist? It's a treaty norm or it's customary law norm? The last question: if we have many treaties, many norms, which are contradict to one. But it's only one norm of customary international law. It's possible to say that this one country, considering or following the principle of customary law, violate the treaty law. What is higher force, treaty law or international customary law? Thank you.
Can you introduce yourself?
Myself, okay, excuse me. My name is Anatoly Kapustin. I'm from Russia, Moscow Institute of Legislation and Comparative Law Studies. Thank you.
Professor and Dr.
Tadeusz Krzywda, Minister of Foreign Affairs. I have a very simple question, I'm not a lawyer, to Maria and to Oleksandr. Tell me in simple words, international law was violated or no? Question for Maria and question for Oleksandr. Because I don't understand your lawyer blah blah blah. Thank you.
So, yes, it was. The provisions concerning the use of force was. Yes, it was violated in my opinion, and I mentioned the use of force provisions, which I think already are less clear to you because it's already legal. So certain international law norms were gravely violated. This is the brief response. So, to address bilateral treaties, I started with them.
Yeah. Or you answer first the question.
Okay, let me address
the... And then we'll move to those.
Okay. So, to what extent the situation is different from Kosovo? Kosovo was an entity under... I'm sorry, my phone keeps... Yeah. It was under the United Nations control. There were Security Council resolutions. concerning Kosovo in place, 1244, and by the time they declared independence, the use of force was not used. Just to distinguish it from the Crimea, which happened in a few, and the process was very long, if you all remember, and painful, and involved a lot of death. And the whole Yugoslavian situation is what, 90s, 19s, 2000s, even earlier, I think. In the Crimea, we had nothing. We had an episode of transfer of territory. We had no claims by the country which is now interested in this territory, suddenly remembering about another provision of international and claiming it. So use of force is the key distinguishing factor. I hope it responds to the question. Your self-determination principle, does it exist or not? Various views exist. Some commentators say that we're already done with self-determination after the post-colonial, well, the colonial world. Kosovo, obviously, is an example at our hands to address. Treaty or custom self-determination is mentioned in the United Nations Charter, how it's developed in the provisions of the United Nations General Assembly resolution on friendly relations, and so I would say it's more of a customary international rule that we are talking about right now. What prevails, a treaty norm or customary rule? Well, again, I mentioned that there is this dilemma and this fight between two principles, use Kogan's principle of self-determination and territorial integrity in my speech. However, the use of force is not part of that dispute, right? So it's what prevails, as the ICJ noted in the Nicaragua case, treaty obligations and customary international obligations can coexist and can apply in parallel.
I will try to use as less words as possible. Gentlemen, sorry. Sorry, I'm addressing your question. And I will try to use as less words as possible, yeah? In order not to speak. I will say in one word, if we are not considering 400 bilateral agreements signed by Ukraine and Russia during 23 years, not considering a very peculiar attitude of Mr. Kapustin to customary law, these texts, are they international law? No. They were violated by Russia. That's it. What are the arguments we need? Second point, difference between Kosovo and Crimea. Gentlemen, Human Rights Watch and all other humanitarian organizations has never declared any violations of any human rights on the territory of Crimea. Comparing situation in Kosovo, how lot of reports we read about the bloodshed and blah, 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 which were happening before the issue of Kosovo has become a consideration of International Court of Justice. That's first thing. Okay. The second thing. We didn't have any political party, any political movement before the end of March, of course, yeah? Which was duly represented and duly presented the idea of secession. The last thing, totally different, the case of Abkhazia and the case of Crimea. Yesterday, Mr. Putin and the president of Abkhazia has signed an agreement about further integration. On the 17th of March, the second day after so-called referenda, in the declaration of State Republic of Crimea has declared that their aim is to become the part of Russia, which was done the second day, 18th of March. So, 16th of March, referendum. On 24 hours, the results of referendum, declaration, succession. No, fundamental. In 3 days, very quick, special operation. Congratulations. That's it.
Very good spectacular.
Yes, very, very.
Okay. Any further question? Yes.
And I'm sorry if it is possible to answer question by question because I simply forget. Emotions, sorry. Yeah.
Yes, please.
Marcin Skubiszewski from the Krzysztof Skubiszewski Foundation. I have a question about the Budapest memorandum. Yes, there was, but I add another question on this topic. First, I have read this memorandum, of course, and I believe, it's my understanding, that the contribution of this memorandum to international law is nil, zero, because it just restates rules that already exist both in customary international law and in UN Charter, etc. So, do you agree with my position that in fact the contribution of this memorandum in international law, I'm not talking about psychology or politics, just the law, is nil? And now, if you agree with me, then I have a not legal but a political question. How is it that Ukraine accepted to give away nukes in exchange for a piece of paper which, even from a strictly legal point of view, has value zero? Thank you.
As a former representative of Mr. Kuchma, who is responsible for that, although I was not representing him in the parliament this year when he was signing this memorandum, I can say you that first of all, from the political point of view, we didn't have anything to do at all. And if you imagine that there was a chance for Ukraine to leave the nukes, you are completely mistaken. At the time of signing the memorandum in 1994, I remind you that it was December of 1994, and the newly elected President Kuchma, it was only one chance, well, let's say, not considering the Russian position, by the way, for that time. The most pressure was from the American side, as you know how they deal with all the questions of proliferation. By the way, the second thing, coming back to memorandum and its legal nature. Of course, it's a very, very weak document. And we see this, that one of the guarantors is completely violating Article 2, because Article 2 has nothing to do with the nuclear weaponry. Article 2 of memorandum is directly written there that guarantors are guarantee territorial integrity of Ukraine, period. Now, my Russian colleagues are writing fundamental research that never Russia has guaranteed the territorial integrity in this particular case concerning Crimea. Wow. You know, the idea is that because of the 1,700 nuclear heads, we are receiving their guarantees. Of course, guarantors now are transferring the question in a very peculiar way, Their guarantees are coming to the position. Well, we'll consider, we'll give you the weapons or not, and you will stand and you will battle your integrity yourself. It's a very peculiar understanding of guarantees, by the way. And that's in the position of USA. They're discussing now to give the weaponry to the Ukraine or not. That will irritate Putin. That will irritate Russia. That will, Russian forces are on the territory of Ukraine in the eastern part. And this does not irritate them, by the way. So, the very weak document. Why I'm taking the floor and explaining. In 2009, the President Yushchenko has initiated a new procedure to sign, instead of Budapest Memorandum, a new document. And several notes, diplomatic notes, were sent to all the participators. By the way, France and China, as you know, at the end of 1995, they became the guarantors of Budapest Memorandum also, although they have not signed from the beginning. But by the diplomatic notes, they have become the members of that document. And at the end of the day, in 2010, all the guarantors had said, calm down, everything is okay, we will guarantee your territorial integrity, don't worry, only Russia has started the negotiations, and 4 sessions of negotiations, secret one, as to the Budapest Memorandum were taken by the Ministry of Foreign Affairs until the end of 2012. Nothing at the end. And obvious that's vice versa. Very weak document, very weak, and we are paying for that now. Sorry.
Okay. So, first of all, I don't think we can actually say as international lawyers that by signing even a weak document reciting provisions of the United Nations Charter, it's nil. It actually re-emphasizes the obligations of states in their bilateral relations. They build their state practice based on those documents. Even if it does not develop in detail on the obligations, it's very important to have it in place. I also have, and Oleksandr just reminded me, a quotation from the Ministry of Foreign Affairs of Russia of last year, 1st April 2014, and actually they reiterated it now again, and they call it regarding the allegations of the violations of the Budapest Memorandum in particular. So basically the position of Russia in this regard is that the current so-called, they put it in quotation marks, government in Kiev, which came to power as a result of unconstitutional riot, through its policy, primarily in relation to national minorities, essentially exploded the unity of Ukraine and literally kicked one region outside its borders itself. So you see, it's kind of a recursive argument, use of force by Russia, obligation. So again, in this regard, actually, you know, even if we had this position, and it's not only one piece that we have, it's basically the position is that the legitimate government, its presence in Kiev actually rendered all the Russia's obligations null and unnecessary. So I heard the position that because now there is junta in Kiev, all those, yeah, we had the Black Sea agreements, but under the Black Sea agreements we could have our military forces. Yes, we had to notify, but who would we notify now because there is no government? The government is junta. That's, I'm afraid, a twist of international law because the state remained in place. No arguments are adduced when you speak about it, about ineffective government of Ukraine. As of the Crimean situation, the international law does not speak of democratically elected governments. It speaks of effective governments. I don't think Russia can actually raise this argument, but I'm happy to, to discuss it with all of you here. So, thank you.
Okay, thank you very much. Yes, just two last questions. I'd like to ask the panelists, just give me a minute. I would like to ask the panelists whether you would like to react now or afterwards. Okay, so we keep fine. Yes, please.
Yes, thank you very much. My name is Ilya Nuzov. I'm affiliated with the Geneva Academy of International Humanitarian Law and Human Rights. My question is, why are we focusing so much exclusively on the Budapest Memorandum? From what I understand, there are other bilateral and multilateral treaties executed between Russia and Ukraine. And specifically, I'm referring to the Friendship Treaty of 1997. And from what I understand, there's also a 2003 agreement delineating borders, which was called the Border Agreement or something like this, which reaffirmed the integrity of Ukraine and the borders as they were settled at that time. So if you could comment a little bit on these, on the value, on the significance of these treaties, I would appreciate it. Thank you.
Okay. Yes, question? Yes. Just, we still have some 5 minutes left. Yes.
Hello. I would like to address to Mr. Zadhorozhniy. I'm from Moscow State University for International Relations. Did I get right your position when you're comparing the Kosovo case and Crimea case? You said that in Kosovo there were a high violation of human rights and there were no violation in Crimea. So can you tell me, did I get you right that the nation has the right of self-determination only this right begins only in case of violation? It means that there is no violation of human rights. The nation has not right of self-determination. Thank you very much.
Yes, please answer.
The difference between Kosovo, that's a misunderstanding. The difference between Kosovo and Crimea, that's it, the only one. And I have said nothing more. The difference between Kosovo, the difference between Kosovo and Crimea.
Universal for every country, for every nation.
No, I'm not saying about universality and so on.
Okay, we'll discuss this issue just in our coffee break.
Yes. I have written 12 articles comparing Kosovo and Crimea. And one is published in Netherlands here, Book of International Law, and a lot of arguments on. That's completely different, and I understand that completely differs the situation, completely differs, and completely differs the position of official government of Moscow, Russian government. They were completely against Kosovo, and they were criticizing the conclusion of the International Court of Justice, and now they're using the arguments in this conclusion in their favor. That's very principal position. Sorry. As to the bilateral agreements, first of all, 2003, the agreement on the border, and again, the very importance of the agreement of friendship of 1997 was, for Ukrainian part at least, the let's say, legalizing the borders. And that was one of the questions, as you do remember, the question of the Black Sea fleet, because an agreement on friendship itself was signed in 1995, but ratified, paraffied, how it is called, yes, paraffiring in 1995, but for another 2 years, the parties were negotiating the mainly political issue of the Black Sea Russian fleet. And in 1997, it was ratified by both parliaments, not without political discussions and so on, and it was a difficulty for Yeltsin because it was a real opposition there in Russia because of the question of Crimea. But at least the agreement was signed and put in force. It was complemented in 2012 by a very specific document which the political and legal analysts are now omitting. That's the Declaration on Strategic Partnership between Ukraine and Russia. It's a shame today even to say about this document. But this declaration has also a very long history. It was prepared by the Ukrainian side. From the very beginning, it was named the Declaration on the Essence of Strategic Partnership. And in July, exactly July 12, 2012, this document was signed in Odessa. And in this document, everything again was stressed about the territorial integrity and so on. And the last, this mutual border, 2003, after crisis on Tuzla Island. At that time, I was representative of Kuchma in the Parliament of Ukraine. And I was together with a small group of Ukrainian administrators participating in the process of negotiating. The question was, again, that the limitation of the border in Azov Sea, we have agreed, and we, Ukraine, have completely changed our position, which was taken by Ukrainian authorities in 1991. The position of Ukraine 1991-2003 was that the Azov Sea is an open sea, and this 1982 constitution of the sea. Yes, he's acting there. It's an open seas, high seas, and so on. It was a stupid position, and we have changed it. And 2003 document, we have signed a complete set of the documents. One of them was about the Azov Sea, and we have agreed that this is closed sea of two states. And we still, at that document, we have agreed that there is a need to delimitate the border between these two states. And the second document was, again, about border. And we have, again, the delimitation committee has started to, demarcation committee. But 9 years, because of the position of Russia, demarcation commission was not working. In 2012, demarcation commission has started to work. It was just only one meeting. Belarusian has taken part. They have drinking a bottle of vodka, has said 200 million euros for demarcation process. We don't have any money. Let's meet later. We are meeting later. Yes.
Okay. That explains the absence of annex, because the border agreement has to contain an annex.
Yeah, the demarcation commission has started only in 2012, and just only one seat.
Okay, my proposal is that we stop for coffee and we restart in at 20 past 11, and then we'll continue this discussion. Thank you very much.